Bankruptcy. There are two very, I mean, obviously bankruptcy is a necessity when you can't pay your bills and things are, you've got creditors after you, and there are you know, bad things happening to you because of financial reasons. A bankruptcy will usually wipe all that away. But there are two areas that specifically apply to you and to people you do business with. One, and I'm not sure how relevant it is anymore, but I remember 3 or 4 years ago when everything was upside down, there were a lot of people doing short sales, and the guy's not here today, and maybe he doesn't even work for it anymore. He did work for Mark, and he had done a short sale and came right down to funding. And the title company ran their final check, and they came up with a Citibank credit card, $8,000. And they would not compromise. They offered him $2,000 and just sign off on the sale. They refused. So the client came to me. We filed a bankruptcy. We got the credit card lien taken off the property, closed in a couple or 3 weeks. And so, you know, everything works. It works that way. You can get specific liens. So if you have a property that creditors are after and you'd like to sell it, but you can't because you've got a recalcitrant creditor that won't sign off on a lien on the property, then at least think about, is this person eligible to file a bankruptcy? I mean, obviously if there's, you know, if they own the property free and clear, that's not going to work. Then you know, they'll just have to pay it out of escrow. But in that case, it probably wouldn't be a short sale. But the point I'm trying to make is that if you've got a lien against a property, a bankruptcy could handle that. So that's one of those things that now you know something that you didn't know, hopefully, or hopefully you did know. I wish you were all smart and knew everything. But
yeah, on bankruptcy, what are the parameters as far as assets or net worth that someone can have? Is there a ceiling where they say, okay, look, your assets are too much, or, you know, you're not eligible for bankruptcy?
Well, the answer to that is yes and no. There are three kinds of bankruptcies that most common people are involved in. There's Chapter 7 bankruptcy, Chapter 13 bankruptcy, and Chapter 11 bankruptcy. Chapter 7 bankruptcy is just a total liquidation. You can keep everything. For example, if you own a house but you're underwater, you have no equity in it, or your equity is less than what your homestead is, then you can keep your house. There's no problem with that. You can keep cars unless you have a lot of equity in them. You can keep all of your household furnishings, your clothing. You can't own a $30,000 diamond ring and keep that. The trustee will want to sell that. But for the most part, for most people, you can keep everything you have and you can wipe away all your debts. That's a Chapter 7. Chapter 13, that is where you, usually you do that to save a home. And what you can do is, if you get behind in your payments, you can set up a plan if maybe you're $20,000 behind in your payments. You will set up a Chapter 13 plan and make an agreement to pay that $20,000 over either 3 or 5 years, depending on your financial status. Now, as far as limitations are concerned, there are limitations with that. You can, if you have, I think it's $360,000 right in that neighborhood of unsecured debt. If you have more than that, then you're not eligible for a Chapter 13. Or if you have more than $1 million in secured debt, you're not eligible for a Chapter 13. So if you have a real valuable home that you have more than $1 million debt on, then you're not going to be eligible for a Chapter 13. But you are eligible for a Chapter 11, which is incredibly expensive. So most people aren't able to do that. I mean, whereas a Chapter 13 will cost maybe $3,000 or $3,500, Chapter 11 will cost you $10,000 just to think about doing it, and it will probably go up from there. But on the other hand, if you owe $5 million on your house, maybe you have the money in the cash flow to do something like that. Yes.
Another question, I hope you don't get tired of me.
Not at all.
On BK, I thought in my experience, I have an experience before that we found out that the property itself is included in BK and we cannot sell. And we cannot purchase the property because they said it's in BK, but you said in order to sell, you put it in BK. So can you clarify that?
Well, you have to get permission from the court. If you do file a bankruptcy, everything that you own goes into the bankruptcy estate. So the bankruptcy estate owns the house, but you can still sell it. You just have to get permission from the court to do that. And if it's in your benefit, if you're doing it to defraud your creditors, then the court's not going to allow you to do that. But typically, that's not the case. Typically, your creditors, they like Chapter 13 because Chapter 13 is a reorganization as opposed to a Chapter 7, which is a liquidation where you just get rid of everything, get rid of all your assets.
So you don't have to wait for discharge of the BK in order to sell? You
No.
just ask permission?
No, you file a motion for consent to sell property, or once everything's done, you just dismiss the bankruptcy, and then you can do whatever you want to.
And then the creditor will be back.
Maybe,
Dismiss.
but maybe not. It depends. What I had in mind when I said that was, again, it was one of Mark's employees. They had a sale all done. In fact, they had, I think, something like $200,000 equity in the property, but they were behind in the payments, and the lender would not agree to postpone the sale. So we filed a bankruptcy to stop the sale because the bankruptcy will immediately. And now we have electronic filing, so I can file, a bankruptcy at 1 o'clock in the morning, and that'll stop a 9 o'clock foreclosure the next day. And then once they've done everything that they need to do, then you just dismiss the bankruptcy and the property sells and the lender gets paid and everything. But those things happen in bankruptcy. But you're right, if you file a bankruptcy and you get rid of this lien and then you dismiss your bankruptcy, then the lien comes right back.
Right.
So you're right. You are right about that. That doesn't work. But if you go ahead and you get your discharge, then that lien is gone forever.
Okay.
And then there's one more thing. Mark said you'd like to be out by noon, so let me just very, very quickly. And it's not as big a deal now as it was, I don't think. But there's a really neat thing in bankruptcy, where if your house is worth less than your first trust deed, and you have a second trust deed that is completely unsecured, you can file a Chapter 13 and you can get rid of that second trust deed completely. It is completely stripped. And now you have to do your plan, you have to go through the whole thing, you have to wait 3 years. You don't have to make payments on it. It just sits there. But if you go through and you keep up with your plan payments and you pay the creditors you're supposed to pay and not pay the creditors that you're not supposed to pay and do everything right, when you get your discharge, then that lien is gone forever, even if the price of the house doubles or triples.
It's based off the current value.
It's based on current value, and there's questions the judges fight amongst themselves. Some judges say it's the date that you file your bankruptcy. Other judges say no, it's the date that the property is appraised or you have to file your motion. But usually that doesn't make a whole lot of difference because it's very close together.